So welcome, Christine. Thanks for doing this with me. I know I already said your name, but if you could just introduce yourself really quick.
Yeah, hi, I'm so excited to be with you. I'm Christine. I'm an immigration attorney. I'm licensed in Alaska and Washington, D.C., and both are UBE jurisdictions. I
Woohoo! Am I
graduated
trying to
from
be
Lewis
like
and Clark Law
you?
School. Yay.
Yay! Love some West Coast love.
Yep.
Okay, so the first thing we're going to do, I am going to read off this MBE question, and
Oh,
let's both just take a few seconds to think about what you think the answer is. And
yeah,
I'm going to talk out loud because I'm trying to actually study when I do these questions, and I'm going to say
totally.
this is what I'm thinking. I'm thinking these are the answers. What do you think? And then when we both come to a conclusion, we don't have to agree, but we'll come up to a conclusion what we think the answer is, and then we'll jump to what
Okay.
the answer is.
Hey, great. All right. I'm getting flashbacks.
Is the testimony of the second witness admissible? Okay.
Oh, God. This is my worst subject.
Evidence.
Okay, let's do it.
In a civil trial for fraud arising from real estate transaction, the defendant claimed not to have been involved in the transaction. The plaintiff called a witness to testify concerning the defendant's involvement in the fraudulent scheme. To the plaintiff's surprise, however, the witness testified that the defendant was not involved and denied having made any statement to the contrary. The plaintiff has now called a second witness to testify that the first witness had stated, while the two were having a dinner conversation, that the defendant was involved in the fraudulent transaction. Okay. Uh, civil trial. Okay, so we're in civil, we're not in criminal. And defendant is claiming not to have been involved in a transaction. Plaintiff calls a witness to testify concerning the defendant's involved in the fraudulent scheme. Okay, so the plaintiff is thrown off because the witness switches up and says that the defendant wasn't involved and denied having made a statement. So the plaintiff is now calling second witness to testify, first witness. Okay, so it's like he's trying to impeach the first witness while the two were having a dinner conversation that the defendant was involved in the fraudulent transaction. Okay, which is technically hearsay, but if you're using it to impeach, that's the grounds that we can use it. Okay. Is the testimony of the second witness admissible? A, no, because a party cannot impeach the party's own witness. Well, that's false. So I'll get rid of that. B, no, because it is hearsay, not within any exception. I feel like my old self before studying more evidence, I would be tempted by that one. C, yes, but only to impeach the first witness. That's what I'm leaning towards. D, yes, to impeach the first witness and to prove the defendant. No, we're not here to prove the defendant's involvement. That's no, can't be used for that because that's what truth of the matter asserted. That would be trying to use hearsay to prove the truth of matter asserted, and that we're not allowed to do that. So I'm gonna go with
Yeah,
C.
I agree.
Yes.
That was my first instinct.
Mm-hmm.
Evidence is my weakest subject for sure, but I totally agree with all your reasoning and why. I don't remember the hearsay exception super well, but I know that you can use hearsay to impeach somebody, or at least I think I know that.
Yes. No, I agree with you. Evidence is my second weakest subject. I am ashamed to say that constitutional law was my weakest subject.
No, me too. It's because it's so squishy and it's changing all the time.
Yes.
Yeah, for reasons we all know.
We have a lot of live examples of constitutional violation, so it's an interesting time. But that was my lowest in the diagnostic, like my lowest section. So I started with that section first. And my second lowest was evidence. I still struggle a lot with the difference between non-hearsay and exceptions to hearsay. Like that whole thing is still a little fuzzy. But I feel like this one, I think we're both right. I think C, but only to impeach the first witness. All right, let me
I
see.
agree.
Okay. Yay. C is
Yay, we did
correct.
it! I'm shocked.
Yes. Although there is no exemption or exception to the hearsay rule that makes the testimony of the second witness substantively admissible, it may nevertheless be used to impeach the first witness in court testimony as a prior inconsistent statement. A is incorrect. Under the FRE 607, the credibility of a witness may be attacked by any party, including the party calling the witness.
Right.
B is
That makes
incorrect.
sense.
Yes, that was the one I felt very confidently at the beginning, being like, no, that's not. Yeah. B is incorrect. The prior statement is not being offered for the truth of the matter, but rather to impeach the witness's credibility, and as such is not hearsay and is admissible for that purpose. D is incorrect. The statement is admissible to impeach the first witness, but that is all. No exemption or exception applies to prevent a hearsay violation if it were offered for the truth that the defendant was involved. Christine, look at you. You
Yay.
still remember things.
Well, I don't know. So much of this is like gut instinct. And the other really weird thing is that even though immigration is all civil and we do civil like trials and administrative courts, there's no hearsay rules or like there's no evidence rules in immigration court. Mm-hmm.
What?
Yep. Yeah.
So you just be
It's
like
the Wild
bringing in all
West.
kinds of stuff. Like,
Mm-hmm.
really? I learned
Yep.
something new. I didn't know that.
Yeah, I know. So that was kind of why I think in law school and also studying for the bar exam, I was like, oh, none of this matters.
Now, I am going to read you a couple of news pieces that I love to find on the darkest corners of the internet about random things happening in the bar exam universe.
Oh my
And
gosh, I heard about this one that you're gonna read. Sorry,
really?
I looked
Oh, yeah,
ahead.
you looked at
Yeah.
no. I was like, this is crazy. So the first one is New York cardiac arrest. This is from the July 2025 exam. Hofstra University, a woman from Fordham Law collapsed in the exam room from cardiac arrest right before the lunch break. Witnesses said she stopped breathing and turned blue. People nearby started screaming for help. The proctors did not pause the exam. The clock kept running. For everyone else in the room, they just kept going. After she was taken out, test takers got 0 updates, 0 guidance, and here's the cherry on the top. The Board of Law Examiners had their phone lines closed the entire testing period, Monday through Friday, so nobody could even call to ask what was happening. The board later released a statement defending how they handled it, and they called it a scheduling issue. That's crazy. So crazy.
So crazy. Yeah,
Oh
I
my
remember
gosh.
hearing about this and just being like, yeah, is anybody really surprised that someone went into cardiac arrest in the exam and nobody did anything about it and you just had to keep going? Like if that's not the bar exam, I don't know what is.
That is crazy. As a test taker, I could not, like, I don't care if they were even like, we're pausing for 5 minutes. Like, my brain, I'm done after that. Like, I'm looking over, like, this person, is there an ambulance? Like, what's happening? I
Yeah.
don't know. Honestly, it makes me, I mean, I already know the type of profession that I'm going into is not they call them sharks for a reason, but that is wild. That is just straight up like inhumane. Like, it's so
Yeah.
crazy. It's
Yeah.
just like,
100%.
take my money, make me suffer in this test, and like if you die on the floor, who cares? Like, that
Yeah.
is crazy. Here's the next one, which I found this also comical as well, that California bar is trying to use AI. California bar exam disaster. This is for February 2025 exam. They had a new software platform and they were using it for the first time, and it collapsed in real time during the exam. Nearly 60% of test takers reported that the software froze or crashed during the MBE, and over 60% said that the questions wordings didn't actually match standard legal terminology. Like, the questions were
So
read wrong.
crazy.
75% said copy and paste didn't work during the written portion. And then, buried halfway through the state bar press release, some of the multiple choice questions were written by non-lawyers using AI. The same company evaluating whether the questions were valid were also writing them with AI. And those questions were not NCBE licensed. The Board of Trustees ordered an independent investigation after 2 hours of public comment from furious test taker. No way. I as soon as my computer was crashing the first time, I'm immediately like, nah,
That happened?
protest.
I didn't know that happened. Your computer started
Oh,
crashing?
no, no, not me. I'm just saying, if
Oh,
that happened to
oh,
me, I would immediately be like, "Proctor, I'm not no, I'm not ta I'm redoing this test. I don't know how many other times my computer's gonna crash on me." Over 60% of people taking the exam, I hope that if someone failed, that they'd get a refund and a free redo because that's
yeah,
no way. Mm-mm. I wouldn't
yeah,
even sit through the rest of it. If my thing crashed once and it was,
yeah,
like, halfway through, I'm like, I'm not doing finishing this exam."
yeah. I mean, I almost think it's crazy that, like, you have to use a personal computer for these
Yes.
because, like, they're so concerned about security and, blah, blah, blah. But then that was the other thing. Honestly, it's sort of like at Oxford. Remember how they were trying to make us take exams without access to get, like, outlets? And people were
Oh,
like, "Excuse me, there's no power in these buildings." And, like, I don't know how your setup was, but, I mean, ours was pretty comfortable. We were in, like actually, we were in a hotel,
nice.
for mine. Yeah, but, yeah, so everybody I think had, like, outlets and everything, like, you could plug in and not worry about that, but it was still shocking to me. I was like, thank God I have a relatively new laptop, but if I was using my old one, I don't know that it would get through this, or, like, I don't know that it would have been up to date enough for the software.
That's
I don't know,
actually a
it's
good
just a
point. Yeah. I hope that I wonder if it's, like, state bar by state specific, but you would think and this is me, like, policymaker hat coming on, and, like, there should be if there doesn't exist one for the bar, I don't know if there does, but, like, a petition for if you make under a certain amount or even if you can just prove, like, financially you're in a tight, squeeze. And if your computer doesn't meet the requirements, you should get a free loaner. But there should be something where you can have it like on loan and like check one out. Or you know what? Actually, let's put it back on the law schools. All this money that we give them, they should be allowed to have a free laptop included with that tuition.
100%, 100%.
Thanks so much for listening. If you found this even remotely useful, please share with another fellow bar exam retaker, and don't forget to subscribe to get notified when new episodes drop. See you next week.